Hi, I'd like to introduce Heather Martin. Hello, Heather. Heather's famous with a lot of us. Heather Martin is a copyright officer, e-learning and reserve services at University of Guelph, and it's here to present. Thank you.
Okay, first of all, make sure everyone can hear me. If you can't at any point, just wave, because, sometimes I move away from the microphone too far, and if I do that, let me know. Secondly, I want to warn you that this is about copyright. There's a lot of copyright in it, and if you've just had a big lunch and you're sitting in a warm room, I won't be offended if anybody falls asleep, okay? But I'm going to try and keep it interesting, and we'll maybe try and breeze through some of the more technical parts, and I'll spend more time on the more interesting ones. So copyright is often seen as a barrier to accessibility, and rightfully so. I think I've heard lots of people say this. I'm sure you have too. We have accessibility legislation provincially in Ontario and some of the other provinces, obligating us to do certain things, and then we have a federal Copyright Act that seems to not provide us with the opportunity, that seems to actually prohibit us doing some of those things. Is it possible to actually successfully provide alternate format copies and stay within copyright law? It actually is, and I'm happy to say it's actually easier now than it has been in the past. So copyright, the problem with copyright, if you see it as a problem, is that it protects works in all formats, basically every work imaginable, from software to obviously books, newspapers, images, works of art, you name it. Everything is subject to copyright protection. And the notion is that it is to protect copyright owners from unauthorized uses of their works, which I think everyone can understand. You put a lot of time and effort into creating a work. You don't want it to be distributed and randomly copied, and especially if that's your source of income. So I think everybody understands the premise behind copyright. The other issue for those of us who need to make copies is that the term of copyright in Canada is the life of the author plus 50 years, soon to become 70 years, thanks to the recently renegotiated NAFTA agreement. That's a long time. So chances are when you have something that you need to copy, it's still going to be in copyright. It's not going to expire for quite some time. So generally, I say to people, when in doubt, presume something is protected by copyright. Having said that, we do now have Creative Commons and other kinds of open licenses that will often grant you some of these rights up front. They're wonderful. I'm not going to spend a lot of time on them today, but so certainly there are ways in which copyrighted material can still be copied without you needing to seek permission. And we also have exceptions in the Copyright Act as well. So you've heard about Section 32 this morning. I'm going to talk a fair bit about it today. There are other exceptions in the Copyright Act as well. Exceptions are actually exceptions to the rights that copyright owners have. They're also known as users' rights. You heard Victoria talking about that this morning. And exceptions essentially allow for the reproduction of works without permission or payment in specific circumstances and generally within defined limits. The exceptions usually have parameters around them that specify when they can be used, how they can be used, and whether there are any restrictions or limitations around that. These are some of the exceptions that you may take advantage of when you're making accessible format copies. Everybody's probably heard of fair dealing. Fair dealing is probably the broadest and most flexible exception that we have in Canada's Copyright Act. In the US, they have a similar, not quite the same exception called fair use. Fair dealing allows for copies to be made for research, private study, education, criticism, review, parody, satire, news reporting. But generally, fair dealing, because one of the requirements of fair dealing is that your copying also has to be fair. Not that fair is defined in the copyright legislation, but it's generally accepted that it doesn't allow for the copying of entire works. So fair dealing may enable you to make copies of some things, an article, a single chapter, an image occasionally, in certain formats, but it doesn't give us the kind of blanket permission to make copies in accessible formats that Section 32 does, for example. And I'm not going to spend a lot of time on these, but there are educational exceptions in the Act that would allow you to make accessible format copies for purposes of instruction, and also for use in exams and tests. There are library and archives exceptions in the Act that may allow you to make accessible format copies in some cases. These are generally exceptions that are fairly narrowly defined. And then there's Section 32. And I'm going to just talk a little bit more about the history of Section 32. Section 32 was introduced with the 1997 Copyright Act amendments into the Act. So there actually, prior to 1997, was no exception in the Act that was specifically for persons with perceptual disabilities. So I actually can't remember. I don't know if anybody in the room knows. Do you remember what you used to do before there was Section 32? I asked permission for everything, I guess. It's hard. I really don't know how we handled that before 1997. However, thanks to some very successful lobbying on the part of organizations such as CNIB and other organizations that were acting on behalf of users with perceptual disabilities, the Section 32 exception was introduced into the Act in 1997, and we've been using it ever since. It had limitations, some similar to what we have now. It excluded reproductions of cinematographic works, and back then of sound recordings and broadcasts as well. It prohibited the making of large print books, and it, of course, had the commercial availability requirement that we still have in the Act today. And many of these limitations to this exception were the result of aggressive lobbying on the part of rights holders organizations who were concerned that this was going to be the thin end of the wedge and that really wanted to ensure that they protected their copyrights. And so when this legislation was introduced, these were considered to be safeguards that would protect copyright owners' rights, while also allowing copying for users with perceptual disabilities. After 1997, the next significant amendment to the Copyright Act was the Copyright Modernization Act, which happened in 2012. So that was quite a fairly long stretch. There were lots of attempts at copyright reform in the interim, but because of elections and other things happening, we didn't actually get the Copyright Modernization Act passed until 2012. In terms of accessibility, the amendments were fairly minor, depending on how you look at it. Education was added to the list of fair dealing purposes. Before 2012, education was not actually listed separately. We relied on private study, research, criticism, and review to enable educational copying. So it's quite possible that, that did in fact expand the scope of fair dealing as far as the education sector was concerned. And I bring it up here simply because our fair dealing policies, for instance, changed and were broadened as a result of this, which may have also permitted a wider range of accessible format copying as well if it fell within the parameters of fair dealing. The 2012 amendments also mandated a 5-year review of the Copyright Act. So essentially, the Act, Parliament had to review the Act every 5 years. And I'll talk a little bit more about that later. That's where the 2017 Copyright Act review comes in. The other really quite significant thing that happened, though, in 2012 was that digital lock provisions, digital locks are also known as technological protection measures, These were introduced in the 2012 legislation. And essentially what happened is they made it, they made it an act of copyright infringement to actually remove or circumvent any kind of digital lock or technological protection measure that was on a work. Think things behind password protection, things with copy limits. I'm sure you can all think of examples, digital watermarks. So to remove those things is considered copyright infringement under the new digital law provisions that were introduced in 2012. Technological protection measures can either control access to the work itself, or they control your ability to copy and paste, or make copies of the work. So there are two ways in which a work can have technological protection measures attached to it. And the new law did have some exceptions. So if, in fact, you were copying under Section 32 on behalf of a user with a perceptual disability, there was an exception that said that it would not be infringement. You were permitted, in fact, to remove a technological protection measure in order to make those copies. But the problem was that there was a requirement that in doing so, you didn't unduly impair the technological protection measure. And that was kind of a confusing term. Nobody really, I don't think, was quite sure what it meant. You know, if once you take it off, can you put it back? At what level can you not unduly impair it? There were lots of questions around that. And so I think it was, if not an absolute barrier, I think it dampened people's, there was a lot of lack of clarity around whether or not you actually could remove a TPM in order to make an accessible format copy. So I think that it was a problem. I'm not going to talk a lot about the Marrakesh Treaty, but what I do want to talk about is the way the Marrakesh Treaty changed the Copyright Act once again. I think there were amendments made in 2016 to the Copyright Act that were required as a result of us ratifying the Marrakesh Treaty in Canada. So Canada, as you heard this morning, was, I think, the 20th country to ratify. That brought the treaty into effect. And then there were some things in our copyright law that needed to be adjusted in order for our law to be in line with the treaty. So there are a number of things that changed. The language of Section 32 was updated to clarify specific works that the exception applies to. Before that, there had been some kind of omissions and things that were not clear, but this basically, Section 32 was amended to make it absolutely clear that both the type of content you could copy as well as the type of copies you could make, that it covered everything. There were some omissions before that that were sometimes a source of confusion. The restriction on making large print copies of books was removed. That had been around for a long, long time since Section 32 was implemented, and that was taken away as a result of the Marrakesh Treaty amendments in 2016, so that was great news. There was a modification to the definition of print disability to include artistic works as something that a person with a perceptual disability would not be able to perceive. And there was an expansion to the purposes for which digital locks can be circumvented when you are copying, making accessible format copies. And it was expanded to include situations in which a nonprofit organization is making copies to share internationally, so that you could also remove a digital lock in order to enable that to happen. And the other thing that was really good news was they took away this unduly impair language, so it kind of lifted some of the confusion and concern around that, and meant that there were actually no restrictions on when you are able to remove a digital lock when you are copying for the purpose of creating an accessible format document or an accessible format work. Unfortunately, some obstacles remain. Victoria talked about some of them this morning. cinematographic works are still excluded. The commercial availability requirement is still there. It needn't be interpreted restrictively, but it's still something that I think people find onerous, and it would be nicer if it wasn't there. And the other thing that I haven't mentioned yet, but I think is a cause for concern for anyone who's making accessible copies, is that often the terms and conditions of licenses that libraries have with vendors of content will prohibit the making of accessible format copies, or else they, if they don't prohibit it, it's more restrictive than is allowed under the law. So that is a bit of a problem. And one of the things that I'll talk about in a minute is the ways in which the Copyright Act review has taken on some of these issues. So I don't know if everybody followed the Copyright Act review last year. It was kind of my main source of reading material for most of the year. It occurred throughout 2018. The review was scheduled to start in 2017. By the time it was really underway, it was 2018, and it took most of the year to get through it. There was extensive public consultation. There were more than 40 public meetings across 6 cities in Canada. More than 209 witnesses appeared before the committee, some of whom are in this room. There were open mic sessions at certainly on their cross-country tour. People were able to just come up to an open mic and ask their questions and make their case for copyright changes that need to happen. And there were also 191 written submissions or briefs. Again, can come from any member of the public. They came from individuals. They came from organizations, and not just organizations in Canada as well. International organizations contributed briefs to the review. So there was a huge body of material there. And I would say a significant number of different and conflicting interests that were brought forward in terms of how the Copyright Act should change. And I'm not even going to start to talk about what those were at this point. I wanted to talk specifically about the submissions that addressed accessibility, and there actually weren't very many. I was kind of surprised. I can't claim to have read all of the submissions or even completed reading all of the testimony, but I am only aware of 3 that actually addressed accessibility-related issues. One was submitted by the CNIB, and it actually wasn't about Section 32. And then in the 11th hour, both the Oakville accessibility community, a bunch of several members from that community, as well as the Oakville video community, decided to submit something about the cinematographic works limitation in Section 32. We just thought, too good an opportunity to miss. Nobody else has said anything about it. And so our feeling was that we really shouldn't miss the opportunity. And I think members of the Oakville accessibility community sent ours in less than 24 hours before the deadline. So but it's in and it's up on the website. I've actually included a link at the bottom of this slide to our submission, and the slides are being made available. So you know, if you want to go and read it in its entirety, please do. We had a single focus, and that was to remove the limitation on cinematographic works. That was our primary recommendation. There are other issues we could have tackled. You only get 2,000 words. And we also felt that some of the other groups had tackled issues such as protection of contract overrides. So for instance, protection of exceptions from contract overrides. There were a number of submissions, especially from library associations, about that. So we didn't feel we needed to necessarily readdress it here. And we decided to focus solely on the issue of providing accessible format copies of videos and films, and how Section 32, as it is currently written, makes that extremely challenging. So we talked about the AODA requirements and what we were obliged to do under those requirements. We then talked about the challenges of providing accessible format versions of video content, why that is a problem for us. And then, and a shout out to Mark Weiler on this one because it was his idea and I think it was brilliant, we actually included a fairly detailed case study of a university student who needs, a fictional university student, who needs to have an alternate format copy of a video in order to complete, in order to complete her classwork, and how the Section 32, in fact, puts her at a disadvantage. Not only when compared to her classmates, but compared to people with other types of disabilities. So this was essentially what we focused on in our submission. And I'll just read you our main recommendation, which was sort of the key to the whole thing. Currently, Section 32 of the Copyright Act does not provide a technologically neutral exception for providing alternate format materials for people with perceptual disabilities. We recommend removing the limitation on reproducing cinematographic works in order to facilitate captioning, video description, or any other acts required to make a cinematographic work accessible to a person with a perceptual disability. So your question might be, well, what happens next? And that's a very good question. The committee is in the process of reviewing all those submissions. They are scheduled to have a report, a public report that should be available within the next few months. I've heard as early as March, although that seems pretty early to me. But anyway, hopefully before the summer, we will see the committee's report. And that report should include recommendations of changes they feel need to be made to the Act. And I think it's probably also realistic to expect that a lot of the submissions they receive probably they won't see their requested changes or recommendations reflected. In some cases, they're contradictory. So some people are going to be happy and some people not so happy. Will there be changes before the next election? Probably unlikely. Even if this report came out in March, election scheduled later this year, it's probably not realistic to expect that any kind of changes to Copyright Act are going to happen before then. So I feel like our work was not wasted, though. The submission that we made, and also the submission of the OCL video community as well, which is equally important, certainly flagged an issue that had not been raised in the other submissions. And I think that we hope that we made it clear how problematic this is in terms of inclusivity and equity in the education sector in particular, but everywhere. When we have this limitation on cinematographic works, and as everyone here knows, they're a critical they're a format that's being increasingly used across all sectors. So my hope is that by submitting the brief that we've raised this issue, made some of the members of the committee, some of our MPPs aware of it, and that whatever happens in the next election, we'll see some changes to the legislation that will address this issue in the future. Thanks.
Thank you, Heather, for sharing all that valuable information. I just want to open up the floor for any questions. We are going to have to shorten up our Q&A a little bit just to get back on track, but we want to make sure that we give space for some questions. Any from the audience or any from our friends that are joining us online? Get you one. Okay.
Hi, Heather.
Hi, Athol.
Over the years, one of the things that's come up in the context of the exemption to copyright for accessibility support is the idea of ownership
Yeah.
That nowhere in the exemption does it say that a student or even the institution is required to own the textbook that is being turned into an accessible format. I'm just wondering if, with the interpretation of that, I mean, if you could talk a little bit about where that is with your colleagues, I mean, whether that's as clear to them as it is to you, and maybe how that question of ownership and copyright exemption has sort of cropped up in different initiatives that people in this room are involved in around transcription and supporting people with alt format.
Yeah, that's potentially a long answer. So I would say, to answer the first part of your question, I believe, from conversations I've had with my colleagues, I believe that we have a common understanding that ownership is not required when you copy under Section 32. That's not to say it doesn't have to be a legal copy. I think it's quite clear you can't make a copy from an infringing copy, but you don't actually have to own the copy. You can legally acquire it. For instance, through interlibrary loan. That would be fine. Borrowing it from a library. In fact, borrowing it from your faculty, from your instructor, might be an option too. There isn't necessarily agreement. I think it's because of, I should say, there isn't necessarily agreement across all institutions. I know that, certainly when ACE was implemented, the feeling was that, through some extreme caution, they were going to be careful not to, they were going to keep ownership of collections separate. And in fact, so I believe the rule is, and Katja can correct me if I'm wrong, but I think it still is, that the institution has to own a copy of the work before the accessible format copy can be made. There have been efforts to try and change this. I'm going to continue with them. I think that now, as we head into collaborative futures, where we are going to be, and that may not mean something to all of you, but if you're an OCL library that's participating in the joint purchase of a new library services platform, there will be issues around shared collections and shared patron. Potentially shared patron database, which are going to blur the lines a lot. And so ownership might mean something completely different to us in that model. So I think the conversation has to be opened up again. And we have to look at the legislation and just reaffirm the fact that it actually doesn't prohibit you from making copies from another institution's collection. If anyone, I'm happy to talk about this at length with anyone afterwards if you disagree with me or have any evidence to the contrary.
Do you have any more questions?
Thanks.